You're listening to On the Job with PORAC, hosted by PORAC President Brian Marvel and Vice President Ben Therriault. On the Job with PORAC is your go-to podcast for insights into the challenges and opportunities facing law enforcement professionals here in California and across the nation. Our goal is to provide an inside look at these issues from the perspective of officers who risk their lives to protect and serve their communities.
Welcome back to On the Job with PORAC, your inside track to the world of law enforcement. I'm Brian Marvel, President of PORAC, and my co-host Ben Therriault, Vice President of PORAC. On this episode, we're tackling a critical issue affecting every peace officer in California, SB 2 and the decertification process. To help us navigate this complex topic, and exclusively to PORAC, we've brought a panel of experts from Post. Bureau Chief Rob Guyton, investigators Dave Peletta, Robby Bringolf, and Kevin Sherburne. Welcome, and thank you for coming here.
Thanks for having us.
Thank you. Obviously, SB 2 was a tremendous change in law enforcement in our profession in California. To be quite honest, I'm surprised that we haven't had certification. We're one of the last few states in the nation to actually do that, considering that we were the first in the nation to create Post, which obviously every state now has. So this episode, we just really want to focus on the SB2. We get a lot of questions when we're out meeting our members. What exactly is Post? It's not like it's a secret or anything, because I always tell people go to the Post website, check out the FAQs. We're partnering now on classes and workshops to present more information. So I really appreciate all of you coming out here and talking about this, because I think it's one of the biggest things that we get questions on. I'm sure you get a lot of calls and concerns about it, making sure that it's fair, it's impartial, the process is being done properly. So, with that, I'm going to go ahead and start out. Why don't we just start out and talk about the Peace Officers Accountability and Standards, Peace Officers Accountability Standards Division, POSAD. And how's it broken up? How's it made? I'll start with you, Chief.
Sure. Thanks, Brian, Ben. First of all, thank you for having us here. We really appreciate the opportunity to come out and talk SB2 and kind of demystify some of this stuff for everybody.
We appreciate that.
So after September of 2021, when the law was enacted, starting in January of 2023, agencies were required to report serious misconduct to Post. And what is Post, right? How does Post kind of fit into this whole thing? Well, Post, look at us as a regulatory agency. We're not a law enforcement agency. We're a regulatory agency. So much like other professions in the state that have certifications, we now have certifications, but we now have the ability to decertify peace officers, right? And what are we thinking about? We're thinking about the public safety, health, and welfare of the citizens, right? And are they going to be impacted by the serious misconduct by a few police officers? So that was the big major change with the bill, SB2. We're broken down, POSAD's broken down into 4 bureaus. We have the Northern Bureau, the Central Bureau, the Southern Bureau, and the LA County Bureau. And we broke it down that way in order to kind of split up all the cases that were coming in, right? And trying to make it easy on each one of the bureaus and kind of have an equal workload. That didn't transpire. The workload in LA County is much, much higher than the workload in other places, but we'll adapt and flexible about that as we move forward.
Obviously, the concentration of peace officers in the LA area is far greater than anywhere else in the state, so it would seem to be that you would get more cases out of there. And also, I think a lot of the chiefs and the sheriffs, when this passed, were like, hey, we need to start clearing house and sending up a lot of stuff. And obviously, we're seeing the numbers, up into almost 30,000 cases that you're having to deal with, which is a substantial amount. I know the media will jump on that and be like, look at this, there's 30,000 cops that are doing bad stuff. But the reality is, how much of that's actually going to really pan out to be what it is in regards to what the anti-police activists are trying to really point to on that stuff. So I guess we'd start out, in layman's terms, what has really changed in regards to SB2? I mean, you've had to create this new division now. You've had to hire investigators. Can you tell a little bit about that?
Sure, Brian. Ben, thank you for having us. We really appreciate coming out, talking a little bit about SB2. So SB2 did 4 things for post. It created our Peace Officer Standards Accountability Division, right? And that division is made up of 4 professional conduct bureaus, North, Central, South, and Los Angeles. It's made up of our Intake and Disposition Bureau and also our Certification Bureau. So that's the first thing it did. The second thing SB2 did is made it so that background investigations for officers who are lateraling, they must contact post, right, to see if there's any allegations of serious misconduct against that particular officer. The third thing the bill did was it allowed post to be now this regulatory agency, because certifications have always been around, basic, intermediate, advanced, supervisory, management, executive. But now SB2 gave post the ability to decertify police officers. And lastly, it made so the public can complain through post. Through our website, you can submit a public complaint about officer misconduct, which, again, never was in the post purview before, but certainly is now.
And Brian, I just add that I think an important part of SB2 and the folks that are looking at these cases are prior law enforcement, and they have law enforcement experience. And when you look at the investigators, I think at last glance, they have over 25 years of experience, and most of them came from agencies where they were doing investigations and or internal affairs investigations. Some were supervisors all the way up to leads of agencies. So I think officers could have confidence to know that we know what we're looking at. It's not somebody that hasn't been trained or hasn't worked in this profession forever. So we remain neutral, but we also put things into perspective, because we know that frivolous complaints are filed on officers that are out there doing a hard job out there, and it is a difficult job. You know, when you put the addition of in-car cameras in my generation in cars, which were followed up by body-worn cameras, well, it gives somebody else, 10 different looks at an angle where you have a split second to react. And I think when you look at what our team is made up of, they're able to put that into perspective and realize that, the majority of the officers are out there trying to do the right thing. The officers that get caught up in SB2 and go through the decertification process, I would challenge that any officer that looked at that case would say, I don't want them in this profession either. That's what makes our job hard. That's what the public focuses on. It's that those one-ofs that, to me, SB2 was created for.
And it's critical that you actually brought that up, because obviously being intimately involved in the crafting of SB2, the original crafters of that wanted no law enforcement investigators at all in that process. And that would have just been an absolute disaster, because now you're going to put people in that have absolutely zero clue or idea what it's like to be in a black and white, work in the streets. I am thankful that it is actually police investigators doing the job, because you're right. They know exactly what to look for and how to work through this. Where a non-police investigator, they'd be lost. They would find 30,000 sustained cases.
Well, it's funny because you look at other certification processes the state has, and whatever, barbering, anything, and there are folks in those types of jobs and professions that are doing the same thing. And I think it's really important that on what you mentioned, the fact from traveling the state, that a lot of the concern that folks have that are working the street at the line level, they want to know that. They want to know that the people who are looking at these things, or overviewing these numerous cases, are not folks that have no background whatsoever, and that's a real key thing.
When you take a use of force incident, and use of forces generally don't look great. And so, to me, having the experienced people look at that and put it into perspective, considering the law, is really what needs to happen as these things go through the review process.
Absolutely. Yeah. Understanding what's realistic.
Yeah. So speaking of that, obviously there's the 9 deadly sins. Sure. In regards to decertification. So maybe we could talk a little bit about that and elaborate what constitutes abuse of police power, bias-based conduct, and maybe if you could provide some examples to help officers understand exactly to understand the categories better.
Sure. When you think about abuse of police power, think about like trumping up an arrest to get somebody in the car, falsifying your PC, saying you found something in the pocket that wasn't there, falsifying a statement. making a bad arrest is that abuse of police power that we're looking at. Not mistaking fact, right? But generating false facts is an abuse of police power. So, and like Dave was saying, just to follow up on that theme, it's like we understand the nuance of doing this job. We've all been out there and had to, pat somebody down and check their pockets, and we understand the probable cause standard. It's when you're making false statements or saying that people said something that maybe they didn't say. That's your abuse of police power. The other one that people are concerned about is the demonstration of bias, right? And
that's another one, though. I think a lot of people have that are like, well, this is subjective, or and you just kind of fleshed out abuse of police power. But that's definitely another one, because people want to know, well, what does that mean? It means something to me, but they want to, cops want a very explicit,
we like a clear set of rules.
Right? Want a clear set of rules.
Yeah.
The world doesn't really work like that, but that's this is how this has to
doesn't
work
mean we
out for you
can't
guys.
want it, right?
Right.
Totally. So for us, I should say that abuse of power has other ways that one could abuse one's power, right? But just to get a general Reader's Digest understanding of it, that's the falsifying evidence, making a false arrest. The demonstration of bias is a little bit more nuanced. That's taken a little bit of time for the commission to come back with definitions, sort of litigate some of the terms that we use in there amongst the commissioners. But essentially, it's if you're demonstrating bias against somebody for a protected class, for being part of a protected class, and that demonstration of bias necessarily makes an average person believe that you'd be unable to do the job objectively or in the best interest of the public, that is a demonstration of bias. The thing to remember is we use a clear and convincing standard for evidence. So when we find these cases, we weigh them against that standard, and then we put them in front of a board, put them in front of a commission, ultimately put them in front of an administrative law judge. So there's many different places where people get to weigh in and test the merit of the case, right? And so, and we also from the get, we're looking at these cases going, yeah, that's not what we meant, right? That's not a demonstration of bias. An allegation of bias is not a demonstration of bias. You really have to be able to come to the conclusion that person wouldn't be able to do their job as a peace officer.
I think it's important to take a step back from the intricacies of those definitions of abuse of power or the bias and look at all 9 of them really are, what are the core attributes of being a peace officer in the state of California? If the individual license holder is not capable of fulfilling those core requirements, then it's a case for one of us to take a look at. Mm-hmm. And so it's not just misconduct, it's serious misconduct. And is there clear and convincing evidence of that, to what Robby's talking about?
And that's the thing that's hard to explain to cops in general too, because look, we operate, on reasonable suspicion, then probable cause, or if you're looking at the for criminal court cases, the terms of probable cause, and then beyond a reasonable doubt. But no one ever talks about clear and convincing. It's only in kind of really niche labor kind of terminology that people are used to kind of talk about this in between this clear and convincing. People are like, well, what is that? I don't know what that is.
It's interesting because it's a much higher standard than preponderance of the evidence. Preponderance is the standard that agencies will use to terminate somebody for employment law. Clear and convincing is a high probability that the allegation is true. It's below beyond a reasonable doubt. Beyond a reasonable doubt is only used in criminal justice system in the United States. So it's a little bit below that, but it's a high probability that the allegation is true. So for each one of us as investigators to establish that allegation is true, we must meet that evidentiary standard, and it's a really high standard. I'm sorry. So we're answering 3 questions. Did the act occur? Did the conduct occur by clear and convincing evidence? Was it a violation of Post-Regulation 1205 by clear and convincing evidence? And the third aspect of it is, are there reasonable grounds? And this is what Rob was talking about, in the interest of public health, safety, welfare. From a licensing regulatory perspective, should this person be allowed to proceed within the profession?
And I think a common question that we get is, because I was terminated from an agency or my agency for whatever reason, will Post automatically decertify me? And the answer is no. For those things that Kevin just articulated, is that we still have to make sure that whatever they were terminated for meets serious misconduct. And then it goes through this process of review. These decisions aren't made in a vacuum, in a silo. There's so many people that look at this at different things to make sure we get it right. Because we understand there's a lot at stake here. We're talking about people's lives and livelihood. And so we don't take that responsibility lightly. And that's why so many hands touch these cases before they actually are seen by the advisory board and ultimately by the commission.
And that's a big deal because I think there's so many cops, because it's so new and because it's, new things and changes takes time for people to adjust to, but people don't see them in silos essentially, or like separate things. They see these things one big pot. And it's like, well, it's not. This is posting your certificate and certification, and this is your employer and all that, and everything that's happening there. And these are separate buckets, separate issues. They're not conjoined. And this just takes time, I think, for that to work out. And that's some of the feedback that we get.
And that's why I think this podcast is important. I think the workshops are important. And also going back to the Post website, to the FAQs on SB2. So we've got the law that created, we got SB2, the law. Post then had to create POSAD. And then you have the 9 directives that you're working under in regards to how the certification process is going to work. So why don't we go from there to what's the actual process? You get the complaint, the department sends it up to you, comes to you for review. What's the next step? How does the officer get notified? Is it a call? Is it a letter? And then let's go through the steps, the process of actual somebody going through the decertification process.
Totally. I may have to phone a friend at some point, but I think I can get us pretty close to it.
All right.
So essentially it comes in like any other sort of triage on a call, like a call coming in. We're gonna receive the report from the agency, the allegation of serious misconduct. That can come from the agency, that can come directly from the public. We can generate our own, but essentially that allegation, that report comes in. Then that gets reviewed by our bureau chiefs and typically distributed to the investigators, right? And the investigators will take a look at these cases. The cases that don't have merit immediately, right? That you can look at them and you're like, this is a report of an allegation of serious misconduct that is clearly frivolous. It's always great to have a number in the negative category when you're like, yeah, we had 20 allegations of serious misconduct come in. One of them was substantiated rather than we had 20 come in and 20 of them were.
I always lamented my local agency when it's not counted because we took care of it. We reviewed the body camera and then it went away. And I was like, well, that's not good. We need to track that so we can track if they come back again. All that data is huge.
Totally. It's one of the bigger concerns that I hear a lot of the field, like officers in the field, like it's a totally frivolous case, or like even chiefs of police are like, this is a frivolous case. And you're like, yeah. And it's good to collect it because we need to look at it to make sure that it's not an allegation. We have to be objective, but also that helps you show that these allegations, where you stand on that spectrum of substantiated allegations. Anyway, we're getting far afield. So the case comes into our agency. We take a look at that case. The investigators look at it to see, okay, is this misconduct or is it serious misconduct? If it's serious misconduct, it's gonna be something that we can potentially take action on. And those serious misconduct definitions are in 13510.8 of the penal code, right? And so we look at those and okay, do we have serious misconduct? Then we look at it from the evidentiary perspective, like can we get to a clear and convincing finding on this? If we don't have serious misconduct, we close the case out with a pretty easy narrative, right? If we have serious misconduct, we don't have clear and convincing evidence and we don't think we can get there through further investigation, then that case gets closed out and that gets noted. And then we might have some that just come in and they're out of jurisdictional time frame, right? Like it's too old for us to take action on, or for some reason we don't have jurisdiction. That we get closed out. The cases that do get investigated, we notify the officer, hey, we're taking a look at your case. You're going to get a letter to your address of record. And I'm going to take this opportunity, since we're talking about it, to tell you, fill out your address of record. Fill out your address of record.
Hey, I tell that all the time.
Fill out your address of record. And the reason for that is we want to get in touch with you. Yes. We want to send you important information that has to do with your certification. Fill out your address of record. Yes. Please make that happen.
And create a post account.
Yeah, absolutely.
Create a post account.
So anyway, that letter is going to go
That's huge.
To the letter that we're investigating you and that we're moving forward on your case is going to come to your address of record. If we find there's an immediate reason to suspend or temporarily suspend your peace officer certification, that is part of the process, and that would happen kind of early on in us receiving the case. that information is going to go to your address of record as well. It's also going to go to your most recent agency and the district attorney's office for the county in which you practiced, right? So it's best to have that address of record on file. But anyway, we'll send that letter out, and then we'll do our investigation. We'll put that investigation essentially in front of two panels, the first being the board, the advisory board, and then the commission. And those are kind of like, to put it in like cops terms, it's kind of like a PC hearing. It's like, do you have probable cause to move forward on this, right? We're putting this thing in front of the board, and the board listens to it and makes a decision. They advise the commission or whether it should go to the commission or not, right? So we're putting that in front of a bunch of people and testing the case. And then we take that case to the commission, we put it in front of the commissioners and test that case again. Do we have enough? And as it moves through this process, the officer's notified, they're allowed to have counsel. There's places where they can make public comment, but it's not an evidentiary hearing at that point. From the commission, the first time, it will move, if it moves for decertification, there's the opportunity for a full evidentiary hearing. And that's at the administrative law judge. It'll go to that administrative law judge. That judge will come back with a finding, and then it goes back to the commission on peace officer standards and training again for a final decision to either uphold the administrative law judge's decision if it's different than the commission's decision, or to move forward with the commission's decision. They make the ultimate decision. And then that's the decertification process on the sort of administrative and civil side. One thing I want to add, just as an addendum. So in this process where we're moving an officer's case through from intake to ultimate disposition, last hearing at commission, prior to even going to our advisory board, we have two internal processes as well. We have a panel of peers that we run our case by. So like tomorrow I'm presenting a case to some bureau chiefs that are going to sit in and listen. So I present the case and I go, what do you think? Do we have it? Right? And internally we go, yeah, that sounds like enough to move forward, or yeah, that sounds like you have a solid case, or maybe they have some ideas on how we might approach an investigation. And then once we're done with our investigation, we have an executive office review. So we sit down with our executive director or our assistant executive director, and we present our case to our chief legal counsel. We present our case with our legal counsel who's working with us on the case, and we tell them the challenges that we have. We tell them what we found. We explain our clear and convincing evidence. And then at that point, it moves forward to that first advisory board hearing. So internally, behind the scenes, there's a ton of stuff happening that is happening prior to even getting to sort of the processes that are built in by statute.
There's been enough of these now with the advisory board and the commission where people can look at the videos and just kind of see how these things roll out and how they play out. And the officer could see what their role is during these hearings and kind of see some of the interaction between the commission or the board members to see what kind of questions are being asked, because they get the information ahead of time. And so they're well versed in the case. So they don't take these decisions lightly, but I encourage people, look at this now, because if you're going through this process, you kind of want to know what's ahead so you can plan your strategy on, do you want to fight your case, or, at some point, do you want to separate your certificate and be done with this? And it's the only decision the officers can make.
Yeah, none of it's secret, right? Like once we're moving down this path, there's information, there's avenues for cops to get the information out there immediately. And I always appreciated that, like having a place to find, it's a resource. It's on the Post website. Jump on there, look at our certification actions, or look at our board meeting minutes and agendas. And those things have attachments on them that'll show you our whole case, our investigative summary, which is like our report, all the attachments. It's a place where you can look at it. You can anticipate the questions that we're having to answer for the advisory board and the commission. And you can look at the minutes from the meetings to see what questions were asked, like Dave said. I mean, it's a really, it's a cool resource to have. And you can see exactly what the work product looks like.
I think that message is getting out there and it's growing. I think a lot more folks are tuning into YouTube and things like that than to watch those things. I mean, and it's no knock to Post, but I mean, like probably a few years ago, they weren't turning in to watch, like Post adding a TAC Med class. Not that there's anything wrong with that, but the amount of people who are starting to pay attention, I think it is getting out there. But different than
to your point, one of the most important aspects of what our job is right now is that outreach, and it's been vitally important for us to partner with PORAC, and PORAC has been co-sponsoring events that we are going out and speaking to your constituents in order to get the word out and to demystify what SB2 is all about. So we have some events that are coming up. They're on the Post website. Kathy Nape here at PORAC has been really good with working with us to get those dates and advertise those. So if you're out there looking for resources, sign up for one of these. We have a couple coming up in Oakland, down in Bakersfield, Madera. I think the northern region, every single region has classes coming up.
We're holding one here at the PORAC headquarters in April. I mean, they're all over. We'll continue to work on adding more. So to go back to the process, when can the officer start defending themselves with you? After once they get the letter, are there opportunities to respond to some of the accusations?
Yeah. In a case where I'm the investigator, my name's going to be on that first letter you receive, my name and contact information, right? And the recommendation is going to be to reach out to me. And please do. It makes it so much easier for everybody to have a conversation. It demystifies, like Kevin said, demystifies the process. But also it gives me an opportunity to say, hey, this is what we're looking at. Do you have anything that you can provide me that might help with your side of the investigation? A lot of times, I don't think any of these things are, I don't think anybody's like caught off guard that they're receiving this stuff. They might be caught off guard that they're receiving a closure letter for something that we took a look at, and they're like, whoa, I didn't even know I had something there, right? Yeah. But the cases that are moving forward, that are going to like commission, and these aren't like, they're not equivocal. And so these are cases where these guys and gals probably had a pretty good idea they were coming. And when we reach out, we try and have those conversations with them. I've talked to a lot of the officers that I've been going through the process with and doing the investigations on. I reached out and talked to them, and they've reached out and talked to me. So that's the main thing. When do they get to defend themselves? At the evidentiary hearing is when that would happen, and that's at the ALJ. They can come in and do a public comment. We're limiting that time frame to right around 3 minutes for public comment. And once the report is sent to the board and to the commission, the time to defend oneself happens at that administrative law hearing. That's a full evidentiary hearing when somebody's represented by counsel.
I would say, I'm sorry, these are investigations. And through the course of an investigation, our job, our mandate is to collect evidence, and we talk to people. And among those people, chief among those people to talk to is the subject officer. I want to have that conversation. And you asked the question, when does the officer get a chance to defend himself or herself? And really, it's from the very moment that officer is talking to me. There are certain restrictions on that I will impose according to our Post Regulation 1206. In other words, although POBAR doesn't apply because we're not the employing agency, I want to give a notice of an interview to that officer. I want to give that officer a chance to talk to me and provide his or her side of the story. But I don't get to that point until I send that subject officer letter, like what Robby is talking about. And so that starts that conversation. And when that officer calls me, I talk about process all day long. You want to talk about process, but don't give me any of your defenses right now. We'll talk about those later. When I have a chance to interview you, it will be on the record. It will be recorded. And most importantly, you'll have a chance to have representation. Talk to your union rep. Talk to your lawyer. Get some help before you come into that interview. And then we'll sit down and you can present your defenses at that time. There are certain other stages that Robby talked about. The board, the commission, the administrative law judge, and then back to the commission again, where the officer can defend himself or herself. But really, it's just part of that conversation.
So here's the part, maybe if I could just dovetail really quick on, like, when does it become a failure to cooperate? Because there's some people, you could see people getting POBAR mixed up with that part of the process, and then it's actually just part of the 9, and like, that It's like, oh, it's a whole separate thing. So maybe you could break that down just a little bit.
Sure. One thing to consider is with SB2, it's changed the paradigm. That relationship between the license holder and post has changed. It's no longer just training academies and supervisory leadership courses. There is now a one-on-one relationship that is separate and independent than the employer-employee relationship. And one of the 9, the legislature deemed one of the 9 categories of serious misconduct was failure to cooperate. It does include language in the post regulation and in the statute that if there are concerns, Fifth Amendment, if there is an advice of counsel, then those are not likely cases that we would bring forward. So it is a consideration as a license holder. We do reasonably expect that a license holder would cooperate with an investigation that is being conducted by a post investigator. But if there is a good reason, for example, let's say that officer is under a criminal investigation and we happen to be getting it. Most oftentimes, we're going to be tolling our investigation pending any criminal or administrative investigation. But if it were to happen where we were looking at that, we're not going to likely go after an officer for serious misconduct for failure to cooperate if the lawyer says, hey, hold on, don't answer that question on Fifth Amendment grounds. On advice of counsel, that person is not going to answer that question. We haven't seen all the facts. Every single one of these cases is very heavily evidence dependent and there are nuances. But more likely than not, we're not going to be charging a standalone single count of failure to cooperate.
And not to belabor the point, and Kevin made it was, or actually it was made that people are afraid when they get those letters on what to do and they won't contact us, and it's bizarre. And when we eventually make contact, they were like, well, we received this, or I received it, I didn't know what to do with it. And the letter explains exactly what the process is and, basically what the outcome is going to be. And what I find in a couple of instances is I'll speak to the person on the phone and we'll have a good conversation. Once you tell them why we're trying to get a hold of them, then they'll make me aware of information that I didn't even know existed, which really helps the case for me to make a determination one way or another on which way that case is going to go. So we encourage officers that when you receive that, don't be afraid. Nothing's going to happen when you make that phone call. We're not going to charge you, make you guilty. I mean, they already know the investigations at post, I would hope, at that point. And all we're trying to do is establish that relationship with the investigator to let them know what's going on.
It's good to highlight. I just think that's a cultural thing where cops, we're afraid of what we don't know. And we act on that.
We're used to doing investigations, right? That's what we do.
Keep
We
it
do
100 there, yeah.
Now we're being investigated, and that's intimidating because we can't control it. We can control what happens when we're on the job in the field.
And we're supposed to. We're taught that way
Absolutely.
in post academies. This is
Absolutely.
how you make this happen.
But ignoring it is not going to make that
No,
go
for
away.
sure.
Right, yeah.
No, for sure. It's a
I know,
good thing to
you get the letter, you go to your union,
Gotta
say, I
deal
got
with
this
it. That's right,
letter,
absolutely.
and then start the process
okay.
and move forward.
And we're very
through
accessible. I think that's
Yeah.
that's the one thing that we want to kind of drive home is like, even if we don't feel accessible, please let us know why you're not able to access us so that we can mitigate that, because we want to be accessible. We want to be able to be contacted. We want to be, we are investigators. We're also consultants. Like, we want to be able to help consult and get you, to make sure that you understand the process and those kind of things. So
I think it'll help the prior law enforcement, the training classes, the partnership of
Yeah.
the outreach that's being done,
Yeah.
I think is all ways to mitigate that.
Yeah.
Can I throw a couple numbers out?
Absolutely.
So they talked about the process. So since the inception of SB2, only 10 cases have been heard by the commission. And to date, 15 cases have been heard by the board. So the commission will hear an additional 5 cases in March, next week, when they meet. And then as it goes back to sustained violations of serious misconduct, to date, there's been 986 cases that we've gone through. Post has not taken action on sustained allegations of serious misconduct.
I know, and the other thing is, I try to tell people, you can actually go to the Post website and you list all the actions with their names and stuff, and that sort of brings me to so you talked about that when they're under investigation, the letters go to the agency, they go to the DAs. Say an officer goes through the entire process, they're completely exonerated. Do you send follow-up letters stating that this officer is exonerated and clear their record?
We send closure letters. We're making some changes to our current website as well for some of our certification stuff. But yeah, we do we send the officer and the district attorney and the agency head letters. In the first set of letters that go out, we ask them if there's a change in status of your investigation or something changes for you as the officer or the agency or the district attorney, let us know, because we want to know, maybe this criminal charge is dropped, maybe the administrative investigation has been determined to be unfounded, or the officer's been exonerated. So we are actively pinging agencies to try and get that information, and we're sending out those closure letters. I think one of the things that we should probably talk about is, well, what happens if I want to hire somebody?
Yeah, that was going to be my next one.
Yeah, like who's from an agency, another agency, they want to lateral over to my agency. And I want to pick this guy up or this gal up, but I can't because they've got a post serious misconduct allegation. Well, let's go back 20 minutes when I talked about the frivolous investigations too. I'm not saying that everything that comes in is one of those, but what I am saying is everything comes in. That's the idea. So the idea is to collect everything, every allegation of serious misconduct, every allegation of misconduct that could meet the definition of something that could affect their certification. Every one of those is a case number, right? And every one of those is going to essentially have that officer who might want to lateral somewhere else show that they have a case open with post. Now, as we move through these things and close them out, there's, what do we think, 30,000 or something cases, right? As we're trucking through these things, but still trying to be as thorough as possible, as thorough as the public deserves us to be, right? This and the agencies deserve us to be. As we're going through these things, those cases will close, and those cases will show as closed cases or unfounded cases or whatever the dispo is. But right now, there's a bunch of them that show open, and the officer might want a lateral, and a chief might, be getting cold feet about picking that person up. Like I said, we're accessible. Number one, or we want to be. Anyway, that's the goal, right? And so call us. And if you're in that lateral process and you know that you have one of these cases open, you can call and ask us, hey, do you have a case on me? We'll tell you if we have a case or not. There's some things we can tell you, some things we can't. The hiring agency is kind of obligated to reach out to us now, right? That's a change. So these people are going to understand if this is one of these where we look at it and go, yeah, this is not a thing. Maybe we push that to the top of our queue and take a look at that case so that we can get that person picked up and the chief to feel comfortable about that hiring process. But we can have that conversation. But not every allegation of misconduct that's at post should prevent somebody from being picked up. There are some agencies I've heard of that have a policy that they're just blanket, nope, we're not touching it. I'm not here to critique other agencies' policies, but what I can tell you is just because somebody has an open allegation with post doesn't mean that they've committed serious misconduct. It doesn't even mean that there's cause to think they've committed serious misconduct. It means that there was an allegation.
I think it's because I haven't these agents. Some of the agencies, if that's their, obviously that's their ability to do so. If that's their prerogative. Yeah. But I mean, that is the perception amongst, I think, rank and file officers. Like, I can't leave. I have a, and that's the wrong perception. But it is. It's a thing. So it's good that you address that, because there are folks out there who think, oh, I have a SB2 case open, I can't go anywhere. It's like, well, that's not the truth.
Here's the thing to remember. We have a mechanism in place to prevent you from going somewhere else if we think you shouldn't go somewhere else. And that's the immediate temporary suspension. And that mechanism exists because we can bifurcate that from all the rest of the cases in which somebody has just had an allegation come to us. If your name's on the decertification list as an immediate temporary suspension, you probably shouldn't be going anywhere else, right? Probably shouldn't pick that person up. Sure. Right? But just because you have an allegation sent to us, that doesn't mean that you're untouchable or that you're tainted goods or that you're even going to be seen differently from the regulatory perspective, right? And we know how agencies work. It's one of the things of having the benefit of people who've been in the profession for decades, right? We understand how it works, and we understand how it looks, and we understand what happens when you get a smack on the back of the hand and people are like, oh my gosh, that guy's tainted, right? We understand that happens, but there are clear mechanisms for us to address people not.
I just think it's an early on phenomenon, and once the phenomenal caseload that you guys are all dealing with and post-ad, once that starts to even itself out, I think then that will transcend like culturally and be like, hey, that's not, again, obviously if you're not on these lists where it's like, yeah, you know what time it is. That aside, like it'll be not as big of a deal because there's still jobs that you're going to have to report that out to the next agency, and if the other agency is doing their job, they should be looking into it anyways, and it's all good.
You bring up a really good point, Ben, because one of the issues is people don't understand the requirement from the start, and that's a really important foundational thing to understand. The requirement is, and I talked about this earlier, but the requirement is any allegation of serious misconduct gets reported to post within 10 days, right? That doesn't mean, if agencies are doing it right, that means they're throwing everything at us. It is a big number, and it sometimes feels impenetrable, but that number represents every allegation for us to look at objectively. And so as that becomes sort of a normalized thing in the culture of law enforcement and in the community, they're going to see, okay, no problem. Everything that potentially could be a serious misconduct is getting reported to post, but that doesn't translate to an allegation where that it even is substantiated at face value or like that there's anything there. It's every little bit should get reported to us. And then from that point, we kind of go through those things and we take a look at it. And if there's cause or we're concerned about something or we are like, yeah, this person probably shouldn't be a peace officer, we'll put a suspension on their certification so they can't move. And they can always, there are some blind spots that we're working through in legal processes to be able to address some of these other issues where maybe an ITS would be appropriate, but we can't get there from here kind of situation. And we're addressing those and we're finding ways to deal with those. But for the most part, you'll know because there's either going to be like a criminal case attached to it or, they'll have an ITS attached to something or it's not going to be, it shouldn't come out of left field for anybody picking somebody up like that. And I'd be willing to bet like everybody who's doing their job out there, not in even an aggressive way, just like doing a good job is probably going to generate a complaint. That's just kind of how it goes. Like,
yeah, I mean,
I don't think you should be in this profession.
That's from the old mantra. Like,
nobody sitting at this table
no
who hasn't
internal affairs complaints. It's like, well, then you must be sitting under a shade tree somewhere.
Yeah,
not
then
doing
you're not.
your job.
You're probably
I mean, that's just
right.
I mean, like
Yeah.
those people. I'm like, my eyebrow raises immediately. Like, well, what do you do? Because there's no way you record a chart. Not that you should have a ton, but that could be justified. Just depends. It's all case by case. Right. And that's the important thing to highlight. But yeah, people who have none, I'd be like, okay, well, I mean, like, sooner or later, like, you're going to do something that someone doesn't like. That's the nature of this job, and
even if you're issuing parking tickets.
Yeah, of course. But that's why I guess this, the citizens in California can rest assured that there's a process in place that there is an accountability matrix and it transcends itself from the local level to the state.
Yeah. I mean, think about the parking ticket example is a fantastic one. Let's say I issue a parking ticket to a car that does not have a driver in it. I haven't run the 28. I don't know who's in the car. And somebody comes back and says, they gave me this parking ticket because I'm whatever, right? This whatever protected class. That allegation should come to post. That is an allegation of serious misconduct, of demonstrating bias. While it might be frivolous at face value, it should come to post. That would go into our queue as a case against Officer Robby for issuing a parking ticket as a demonstration of bias. Now, anyone who looks at that case goes, yeah, that's probably not true, right? Like he didn't see the person, he couldn't have made a judgment. But that's going to be one of those case numbers. And it should be reported to us and it will get closed out and we would investigate it and we get closed out. But that could be a perfect example of what one of those case numbers that somebody doesn't want to pick up a lateral for is. And there may be a case where these guys don't even know that it's been reported to post because it fell within a retroactive time frame. So we're available to have those conversations. And we can do those things through PRA. We can do those things through direct conversation. The whole idea around this is to prevent a bad apple from going to a different barrel, right? So like that's the whole idea. And so we have those mechanisms in place. Just rest assured that just having a post case associated with your name is not the mechanism by which we're doing that.
So let me throw out a couple numbers. So just over 90% of all the cases that we receive result in a not sustained, unfounded, or exonerated result, right? So the vast majority of the cases that we get are probably something post is not going to take action on.
It's a big number. Yeah.
Yes. So if officers want to lateral and they have an open case, like Robby said, that could be a frivolous or one of those in the 90+%, right? Call us, because we will prioritize that. I've done it. I do it probably on a biweekly basis. Prioritize those cases for those officers, get them their closure letters so that they can move on and lateral to whichever agency. Because I can tell you, going out, talk to the chiefs, they won't touch you if you have an open post case. Even though we say it's okay, they won't touch you. And there are agencies that are just like that. So we're here to help. As Robby said, we should be accessible. I hope my colleagues don't go crazy that I just threw it out there. Please call us and we'll raise your prioritization of your case. But
well, why don't we close it out with one last question? Obviously, we talked about immediate temporary suspension. So how many classes of decertification are there? Is it just your decertified suspensions? Are there 3-month suspensions, 1-year suspensions?
It's a good question. We're still kind of working it out.
Okay.
Yeah.
All
So
right.
the commission has been making some findings for doing like stipulated agreements where they're, for lack of a better term, it really looks like probation looks, right? So you might have your decertification kind of like tabled until a certain time period passes. There's that, but really there's suspension, there's revocation. Most of our cases that we put forward, we suggest revocation. That's why we're bringing it forward. The commission can make a determination whether they want to do a suspension, whether they want to toll the revocation and put a probationary period out there with some terms. But yeah, for the most part, through that process, you've got revocation, suspension is an option, and then there's the potential to have sort of a stipulated agreement that's developed through counsel with our counsel and the officers' counsel. Then there's also the 1029, which is a completely different track. That's the 1029 of the government code, right? That tells you all the reasons you can't be a cop, the felony convictions, and now some misdemeanor convictions, believe it or not, 148, 149, a couple of those interesting ones. But yeah, so you get a misdemeanor 148 conviction, you can't be a cop anymore, which is probably good, right? solid move, but yeah. But so the 1029 track is like a different track as well. That's just a function of law. Like that one's like, yep, you're decertified. That doesn't go to a commission hearing. It goes kind of just one solitary track. But yeah, as it sits now, and remember, this is new. We're developing the car as it's driving. I mean, it's new, and I can say from somebody who's recently in the field as a peace officer, I'm proud to work here, and I think we're doing a really good job for where we're at. And we have people who really care about this doing the investigation, and you can hear it a ton of times, and no matter how many times you say it, it still kind of resonates. There's nothing that a good cop dislikes more than a bad cop. We all share that perspective, but we share the importance of the rule of law, the Constitution, and making sure that things are being done appropriately. And we're protecting the public, and we're protecting good peace officers, and we're also being objective about how we look at cases that for potentially the bad peace officers.
Yeah, people want a fair process. Cops want a fair process. The public wants a fair process. I tell people all the time, I don't arrest somebody and drive them to San Quentin. Like, it doesn't work like that. There is things put in place, and that's a very American ideal, and it applies in so many different ways in our jurisprudence. So it's important.
The officers they have due process is what I'm getting at. There's a lot of it built in, and that is a very positive thing. But there are ways for us to immediately take somebody out of play that needs to come out of play. But I'm totally, and I think that most of these guys, if not all these, I speak for all of them, share that sentiment that's.
And I think it's important to note, though, if you self-revoke, that's irrevocable, man. Once you give it up,
totally.
You ain't getting it back under any circumstances.
That's a solid point. Yeah. And that's sort of it's kind of a misnomer right now. And so, but yeah, that's a very important thing to consider. you can self-surrender, but you can't get it back. You can't go to another academy and get it back. And you do get put on the National Decertification Index as well, right? And so for those that play nice in the sandbox with us, they will probably say, yeah, well, if you can't be a cop in California, you can't be a cop here. I think there might be some other states that still don't necessarily care what California says. But for now, you get put on that National Decertification Index. Your name goes up there anyway.
So there's always a thing for the California, for the post certificate, is that the reciprocity always played well outside of California. Like that was a big deal, and
Call it the gold certificate.
why we were such a high standard for law enforcement in the United States, I think, and the work and it's a credit to the work that Post does. I had one more question about. I know the answer, but I think it'd be good for the rank and file to hear from you guys, from your guys' perspective. A lot of times, again, this goes back to the different silos of the, what happens with post and then the administrative investigation, et cetera. A lot of times questions I'll get is, there is, I got, a suspension or something like that, but the arbitration is happening and I won in my arbitration. How does that affect or not affect something going simultaneously on with my SB2 post investigation?
We are informed by the defenses that are brought forth during an arbitration, but we're not bound by them. And for legal reasons that are way too complicated to get into here, collateral estoppel, res judicata, and other fancy Latin words, we're not bound by those. We're informed by the arguments that officers make during the arbitration because we want to know. We want to know, is there something that we don't know yet? Like what Dave talked about when he talks to somebody and he learns new information. So while we're informed by them, we're not bound by them. They're held under different evidentiary standards and they're in different systems. Our system is this regulatory system that in which we operate.
I think it's just good to hear you guys say that because I think I get that question a lot.
If I could just circle back, Brian, you had asked the question, what does the statute really allow in terms of discipline? From discipline, we staff are making a recommendation to the commission of revocation or suspension. The statute really has two choices, and that suspension is up to a period of 3 years. I think that the commission has provided some guidance with respect to the cases Robby earlier talked about, chemical dependency for an off-ramp, so to speak, that might be a negotiated settlement, but there's really two choices, revocation or suspension.
And I think that's an important thing because police officers make mistakes, and we know that. Yeah. And so it's not an all or nothing game anymore in the sense that the commission, and most of them, as we know, are current or past law enforcement, they realize that they've dealt with this in their own agency. And so for them to have that carve out, I think helps the officers understand that, okay, I may have another chance at this, but they also have to skin in the game too. They got to go through their treatments or EAPs or everything else that the department offers them to make sure they're on the right track.
No, absolutely. Well, I really appreciate you all coming in today. I thought this was a great conversation. Hopefully it does demystify a lot of this. Again, I want to reiterate the partnership workshops that we're doing with Post. You can go to the PORAC website under training. We have them listed. We're hitting Northern, Central, and Southern California. We're adding more classes. We'll continue to do this to get the word out. I know the police academies are trying to get the word out on this so the new officers understand. Like I said, it's a generational thing. It's going to take some time, but we will get through there. And the younger folks, this will be the environment that they live in for their whole careers. So, and that wraps up another important episode of On the Job with PORAC. A huge thank you to Post for shedding light on SB2 and the decertification process. Remember, understanding your rights and responsibilities are paramount. It's a two-way street. For more information, check out the resources mentioned on the show notes, including the SB2 FAQs on the Post website. It's www.post.ca.gov. Ton of information on there. They have a data warehouse that's even got more information about California law enforcement, public safety. Remember to like, subscribe, and share this podcast to help us reach more listeners. This is Brian Marvel and Ben Therriault reminding you to stay informed, stay safe, and keep up the great work. Until next time, On the Job with PORAC. Thank you.